This is WLBT Law Call with award-winning broadcaster Tamika Smith and Jackson personal injury attorney Rocky Wilkins. Your rights, your calls, live. WLBT Law Call.
Welcome back to Law Call. Well, we are answering all your questions on being hurt on the job. Joining me tonight is personal injury attorney Harry McCumber and workers' compensation attorney Jonathan Barlow. And we're going to kick things off with another email question. You know, I don't do so well sometimes reading the prompter. All right, don't give me a script. But we'll go by script on exactly what Brett has here. Brett says, I didn't report my injury for a few days after it happened because I hoped it would heal. When I did report it, my supervisor acted like he didn't believe me. He said I wouldn't be able to get comp because it had been too long and I couldn't prove that it happened on the job site. That shook me up enough that I didn't file a claim. It's been 2 weeks and I'm still hurting. What should I do now? Oh, I hate to hear that. Ugh.
Brett's going to be okay. Brett, the first thing you should do is hire a workers' comp attorney and let them file what's called a petition to controvert. That's the document we put before the Workers' Comp Commission to say, hey, Commission, Brett has been injured. I would say that the notice requirement of the statute, which is really what we're talking about, did your employer know you got hurt at work or not? That's probably the most catch-all provision. Every employer that doesn't want to actually take care of you says, we didn't know it happened, even if you told them. And so it becomes kind of a he said, she said. My law partner, Marshall Goff, will tell you the commission doesn't like he said, she said. Mm-hmm. They don't want to do credibility determinations. However, for Brett, based on his email, it only happened 2 weeks ago. And the statute says you have 30 days to file your complaint or your petition. More importantly, the statute goes on to say that even if it's outside of those 30 days, as long as it's not an unjust delay that would impede the defense's ability to respond to the claim and deny it if they think it is the proper way to do it, you're going to be okay. So notice is one of the more thrown around defenses, but it's not always a good one, and so that doesn't bother me.
Yeah, you mentioned something earlier. So in what I do, I usually deal with 3-year statute limitations, and you mentioned certain time constraints. What is the statute for workers' compensation, and can it kind of be extended depending on the filing of certain documents?
So that's also a loaded question, but generally speaking, you're going to have 2 years to bring your claim. Now, if you're getting some benefits paid and your employer is taking care of you, that can extend your statute.
Okay.
And when those benefits turn off, or if you get wages in lieu of benefits, so those 3 things we talked about earlier, the disability benefits, the medical care, and the death benefits, if they're taking care of you, even if you haven't filed your claim, you will extend your claim, the life of your claim.
Okay.
So generally speaking, it's going to be 2 years.
All right, okay, all right. All right, and thank you, Jonathan. We do have another caller standing by. Welcome to Law Call, Teresa, and what is your question tonight?
I was hurt on the job with an on-the-job injury. I have been receiving workman's comp, which has been 66% of my salary for 2 years, which is $3,000. And last week, my adjuster told me that they were going to have to settle with me. I'm 62 years old, and I'll never be able to go back to work again. And my question was, what is a fair settlement?
All right, thank you so much, Teresa. And what is your advice for Teresa?
Well, Harry and I talked about this a little bit out of the set. What's frustrating about workers' comp is that when you're evaluating a claim, when it's time to settle, much like Ted, the insurance carrier's tired of taking care of Teresa and they just want to get her off of their books. They don't want to get into what's called their reserves and impact how much money they have. They don't want to reallocate funds and take care of other people and take out of one pot and put into the other. So it depends on what type of injury she has. We have scheduled member injuries like the arm or the hand or the foot. We have body as a whole injuries. We also have to consider what wages has she lost if it's this full body claim. Mm-hmm. If it's an injury to an extremity, a scheduled member, then we're really looking at what's the loss of industrial use, which I explain as what's the implication of the injury had on my ability to do the job. But what's most important in all of this is what do those medical records say? Much like what Harry does, this all lives in an injury claim. And so Can I do what I used to do? And if not, why? What are my restrictions? What's my anatomical impairment rating? We take those numbers, we put it into an equation, and we don't pull it out the ethos. We have something that tells us this is the value of your claim. Now, with an efficient workers' comp attorney, we will get more money because the act does allow that judge to deviate from the anatomical impairment rating and go up. So oftentimes, you know, for example, a rotator cuff surgery, you're going to get 12 to 15% of impairment rating. We can go and get you more money than what that actual value is. So my advice is always get you an attorney,
Yeah, it sounds
file
like
your
it.
petition to controvert. Even if you've gone the whole time on the workers' comp without an attorney, we can always come in and help kind of put the
Oh,
puzzle together.
okay.
That's
All
right.
right.
Let me ask, so like if I settle a case, I don't necessarily need to get permission, you know, it's just really the client tells me I want to settle or not settle. And when Teresa says, what is a fair settlement, do you have to get it approved? Is someone overlooking the settlement?
That's right.
Saying whether it's a fair settlement, like the commission?
That's right. So
okay.
procedurally what will happen is I'll go to the insurance carrier and I'll say this is the amount, you know, that my client wants, and they'll come back and have some number far lower than that.
Right.
I'm going to file a pre-hearing statement and bring you up to the courthouse if we have to, but usually they don't want to litigate all the way. So once you actually file it's a 9I settlement, it's a petition and an order, the judge will get that, and then it'll go up to the commission. The commission will review it, and as long as they think that your client's getting what they're supposed to and there's no unanswered questions, they're going to go ahead and approve it. Most of the time, they don't want to tell your client what they can and can't take.
I got you.
But it can happen.
Okay, that's great advice. Thank you so much for tuning in, Teresa. And it's time for us to take another break. We'll be right back with more on how you can contact our attorneys.